The record will show the presence of the defendant and all counsel. The jury is not present. We are completing the hearing. We began this morning. The witness has had an opportunity to review Exhibit 604. Ms. Wilmot, you may continue.
Thank you, Your Honor. Ms. LaViolette, you had a chance to review an interview between Detective Flores and Bill Arias?
Yes, I did.
And were you able to view the entire interview?
Yes, I did.
And specifically, you were asked questions earlier by the prosecutor about a 9-second clip of that interview. Were you able to put that 9-second clip into context?
Yes, I was.
And putting that into context, do you see that right prior to that, that the interview, Mr. Arias is talking about Jodi as a teenager?
Yes.
And that Jodi was in trouble with her parents?
Yes.
Because she had marijuana?
Yes.
And because she was in trouble, did they search her room?
Yes.
And that after that, is Mr. Arias describing after that that they searched her room, that Jodi felt like they were nosy parents?
Yes.
And after that, she hid things from them, didn't talk to them?
Absolutely.
And then after all of this context we talk about, after that is where we hear the 9-second clip about since she started not talking to them as much, that she basically, the 9-second clip that she lied to them since then, and she was about 14 then.
Yes.
Putting that in context with what Mr. Arias was talking about as Jodi as a teenager, does this make any difference to you in your ultimate assessment of domestic violence?
No, it doesn't.
Does it, something that she did as a 14-year-old girl, as a teenager with her parents, does that have anything to do with or change any of the evidence that you've seen with regard to her truthfulness when you're assessing a relationship between Ms. Arias and Mr. Alexander?
No, it doesn't.
Does it either help or hurt your assessment?
It neither hurts or helps my assessment.
All right, thank you.
Is anything else?
Just argument, thank you.
All right.
Irrespective of what Ms. LaViolette may say, and with due respect to her position, this appears to be a case where there was shoddy work that was done on her behalf. And one of the aspects of that shoddy work that she did is in taking the defendant's word in this case about the events. There was only one person that she talked to, the defendant, and that was for 44 hours. Gauging or in looking at that statement provided to her by the defendant, this person made the assessment that she was telling the truth. Anything that goes to whether or not the defendant was telling the truth is relevant. I understand that she says that it didn't factor into her assessment, but that's not the inquiry. The inquiry is whether or not there's something out there that may be considered or may cast doubt upon her opinion. Certainly the fact that we have evidence already that at that time, around the age of 14, the defendant saw herself as a victim and never was the victim of abuse, according to the evidence that you just received. It's about that same time that this defendant then begins to be dishonest with her father. And it's, even though this witness here says it didn't affect my opinion, that may be so. That may be legitimately what she believes, but her opinion is flawed. And it's flawed because she took the defendant's statements into account without really filtering them adequately for the truth. And so I believe that it is relevant and should come in.
Your Honor, this 9-second clip absolutely is not relevant, and in fact it's overly prejudicial under 414 and 243. The reason being is, first of all, the state is continually trying to characterize or mischaracterize Ms. LaViolette's testimony by claiming that she only took into account Ms. Arias's words during her interviews. That is not the case, and I don't know how often Ms. LaViolette can say it, that it's going to change anything, because she keeps continuing to tell the prosecutor that not only did she take into account what Miss Arias told her, she took into account multiple levels of information, including Mr. Alexander's own words. She also talks about the fact that there is no evidence at the time that she's assessing this domestic violence abusive relationship. There is no evidence that Miss Arias was being deceitful in any way. In fact, she's talked about the only person who's deceitful has been Mr. Alexander during this time. So, and the second thing is that the state talks about, continues to mischaracterize the evidence that Miss Arias was not a victim of abuse. There is no such evidence. In fact, the evidence is quite contrary to that she was a victim of abuse as a child. So that state should be precluded from continuing to say that as though it's truth, because it's not. The fact that there is something, this one tiny little piece of information from her father, a father who quite frankly has a motive to not be truthful because he's the one who is abusive, a motive to not paint Miss Arias in a good light because of what he has done to Miss Arias. This tiny little piece of information that we have is not relevant, as you heard, to Miss LaViolette's assessment that she did 14 years later. So the fact that a teenager was not truthful with her parents at some point has nothing to do with whether or not her assessment is flawed. It doesn't weigh. And the fact is the state wants to talk about that there is something out there that could ultimately go to Miss Arias' credibility. But that's not how the rules work. And the law is, and evidence is weighed, that if there is something that is so long ago in time and so minute in detail, there is nothing to support it other than what this 9-second clip. If it's so minute in detail, that means it's not relevant. And if there is any relevance, it's outweighed by its unfair prejudice. Based on that, I'd ask you to conclude it.
All right. The objection to Exhibit 604 is sustained. However, the state may inquire about the substance in that clip and whether it would have made a difference to this witness in formulating her opinion.
Judge, maybe just have a clarification then as to how the state may inquire so that we don't get outside of your ruling. What is, you're saying that the state may not get into the details, but what is the state allowed to ask then?
Well, the state is allowed to ask if she has viewed this clip and she's aware of the statement made by the defendant's father and if it would have affected her opinion.
So nothing about what the statement of the father was?
Yes.
Okay. All right.
No, he may inquire about the statement of the father, but just not the circumstances that she opined or that the father opined about the defendant's truthfulness and whether that would have affected her opinion.
So he's allowed, okay, so the state's allowed to ask about the father making a statement as to Miss Arias' truthfulness?
Yes, but not the circumstances.
Well, the problem I see with that, Judge, is that then it makes allowed to talk about her own father talking about her truthfulness because it's her truthfulness as a teenager.
It's similar to the restrictions that were placed on this witness with regard to other information she considered in forming her opinion. If you're not going to object to the prosecutor putting in the tape or having her explain it, then that can happen. But I believe that the state is entitled to question the witness about this aspect in light of her prior testimony regarding what she considered important in forming her opinion about the defendant's truthfulness or credibility.
Okay, I'm not asking for details, but what I would ask is that it just be qualified so that it's an accurate statement that her father made a comment about her truthfulness as a teenager. So that it's put in appropriate context.
From the state, what do you intend to elicit with regard to Exhibit 604?
I would like to ask
Hold on. Go ahead.
if she has reviewed this clip, and that this clip indicates or involves the father, and that the father has questions as to the defendant's truthfulness, and that this statement involves the defendant at the age of 14.
That's fine, Judge.
Okay, let's bring in the jury.